Okay. Thank you.
Okay, thank you, Michael. Good afternoon, everyone, and welcome to our virtual meeting. In my case, it's a good day for a virtual meeting. I'm having a complete whiteout and doubt I could have got in today. So anyway, look forward to this. Hope everyone is doing well. Today is Wednesday, April 14th, 2021, and this is a time and place for the hearing examiner's proceeding for the docket number 20121-006, cause number 072-01, in the matter of the request for agency action of Urban Oil and Gas Group, LLC, for an order pulling all interests, including the compulsory pulling of interests of certain non-consenting owners in a drilling unit established for the production of gas, including coal methane, from the Farron Formation, comprised of the northeast quarter of Section 22, Township 14 South, Range 10 East, Salt Lake Meridian, Carbon County, Utah. My name is John Rogers, an environmental manager with the Utah Division Oil, Gas, and Mining, and I've been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this matter. We'll take appearances of counsel at this time. For the petitioner,
Fred McDonald of counsel with Lear & Lear on behalf of Urban Oil and Gas Group, LLC.
Thank you. The division,
Haley Souza on behalf of the Division of Oil, Gas, and Mining.
and I'm being represented by Charles Lyons of the Attorney General's Office. At this time, we'll proceed with Mr. McDonald with your opening remarks.
Thank you, Mr. Rogers. With me today are Mr. Curtis Turner, the president of Turner Petroleum Land Services, Inc., who is the contract broker for Urban, Ms. Catherine Stifler, who's the senior landman for Urban, and Mr. Michael Wade, the chief of operations of the Rocky Regions. I'd ask that they be sworn in at this time.
Okay. Michelle?
Okay. Will you raise your right hands, please? Will you also speak so I can get you up on the computer?
Here we go. Hello.
Can you hear us?
There we go. Thank
Alright.
you. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God?
I do.
Okay. Great.
The resumes of all three witnesses. Okay.
Ms. Sosa, do you have any witnesses you need sworn in at this time, or do you want to wait on that?
No, we don't have any witnesses.
Okay. Okay. Sorry, Fred.
No worries. The resume of all three witnesses were collectively submitted as Exhibit A in this cause. If separately and individually asked about the contents of their respective resumes, each witness would confirm the same. Mr. Turner will be a fact witness only today. And since this is the first time that Ms. Stifler and Mr. Wade will be testifying before the agency, I will be qualifying them as experts in petroleum land management and petroleum engineering, respectively, at the commencement of their respective testimony. I want to confirm that the hearing examiner and counsel received the substitute Exhibit J and the supplement to Exhibit Z, which we filed on Monday.
Yes, I received those.
Okay, and finally, I also want to confirm that it's acceptable to move for admission of all of our exhibits at the end of our presentation in chief.
Okay, that'll be fine.
All right, thank you. This cause involves the compulsory pooling of interest in the drilling unit established for Farron Formation gas production, comprised of the entirety of the northeast quarter of Section 22, Township 14 South, Range 10 East, near Price. The drilling unit was established by board order entered in cause number 241-09 in 2012. Under the order, only one well in the drilling unit is authorized. A true and correct copy of the 241-09 order was submitted as Exhibit B in this cause. In accordance with the 241-09 order, Urban plans to drill the Leotard 42-22 coal bed methane well in August of 2021, contingent upon regulatory approval. The well will be drilled in the southeast quarter, northeast quarter of Section 22 upon a fee tract which is currently leased to Urban. The drilling unit is a regular 160-acre governmental quarter section comprised of 16 separate oil and gas tracts. One tract is federal, comprised of 40 acres or 25% of the drilling unit. The other tracts are all owned in fee. As originally alleged in the request for agency action, 83.16875% of the working interest in the drilling unit was considered voluntarily pooled. The remaining 16.83,125% was owned by 5 parties which did not initially voluntarily agree to pool. Since the filing of the request, 4 of those parties have leased their interest to Urban, namely William Gorashek, Plaza 106 LLC, Glenn T. Etzel as personal representative of the estate of Jesse Etzel, and Dennis Waters, executor of the estate of Glenn Nielsen. All 4 of those leases contain pooling clauses, allowing Urban as lessee to unilaterally pool the lease, including the lessor's interest therein, which Urban intends to do. Sarah C. Nielsen has not leased or otherwise agreed to pool under acceptable terms. As a consequence, Urban seeks to compulsory pool her 0.29375% interest in the drilling unit. As required under the new compulsory pooling regulations promulgated last June, the requisite notice of opportunity to participate was sent to Ms. Nielsen, but she never responded in writing within the prescribed 30-day time period. A similar notice was sent to Plaza 106, which owns a 5.675% interest in the drilling unit, in writing within the prescribed period. Dr. Reddy, as manager of Plaza 106 LLC, but without counsel, filed a response to the request, requesting additional time to negotiate, to which Urban did not object, conditioned upon the requirement that he obtain competent Utah Oil and Gas Counsel to assist in negotiations. The hearing examiner granted Dr. Reddy's request. Although to our knowledge, Dr. Reddy never obtained counsel, late yesterday afternoon, he sent a scanned copy of an executed lease to Urban. Consequently, Plaza 106 will no longer need to be compulsorily pooled. Urban therefore also seeks to have Ms. Nielsen declared a non-consenting owner in the Leotard 42-22 well. As Ms. Nielsen failed to timely respond to the request, pursuant to Utah Administrative Code Rule R641-104-150 and R641-108-400, I move to enter an order of default against her. It appears Mr. Rogers left the conference.
Fred, we appear to have a technical issue with John. He'll be reconnecting shortly. If we could just pause for a minute.
Sure.
I'm sorry, I lost my link, Fred, about 3 minutes ago. Did you know I was gone?
I saw you leave after I finished up, but I don't know at what point you couldn't hear anymore.
You were just talking about Sarah Nelson, and from that point on, I'm sorry, something just glitched out here.
All right, that's no problem. I'll pick up at that point again. She has not leased or otherwise agreed to pool under acceptable terms, so we're seeking both the compulsory pooling of her interest in the drilling unit, as well as declaring her as a non-consenting party in the Leotard 42-22 well. She failed to file a response to the request for agency action and has not made an appearance today. So we are requesting that she be declared to enter an order of default against her pursuant to rules R641-104-150 and R641-108-400. So you need to rule on that motion at this point.
Okay, I'll accept that, and that's acceptable.
Okay. As to Ms. Nielsen, Urban seeks imposition of a 100%, 300% risk compensation award and the terms of the joint operating agreement it proposed, which is consistent with other joint operating agreements covering nearby drilling units, and the terms of which she did not object as required, have any objection to as required under the regulation. Since a federal oil and gas lease is involved, a communitization agreement is also required to pool all interests and create a proration unit to conform with the board's spacing order. Entry of a compulsory pooling order will help facilitate approval of such an agreement by the BLM. The hearing examiner and the board have jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5 and the implementing regulations at R649-2A and R649-29B. Copies of the request and the applicable board procedural rules were mailed via certified mail to all parties sought to be compulsory pooled. Exhibit Z as supplemented reflects the return receipts or the return mailings or the USPS inquiries as to any mailings for which no return receipt was received. In addition, a copy of the request was mailed to all other production interest owners in the drilling unit at their last addresses disclosed by the BLM and Carbon County records, and also to the BLM as the governmental agency having supervisory authority over the federal lease. In addition, notice of the filing of the request and of this hearing was also duly published in the ETV News on March 3rd, 2021, the Deseret News on March 5th, 2021, and in the Salt Lake Tribune on March 7th, 2021. No other objections or responses to the request were filed. By board order entered on February 26, 2021, this matter was referred to the hearing examiner for virtual hearing today pursuant to Rule R641-113-100. As previously stated, the hearing examiner granted Dr. Reddy's request for a continuance until today. Finally, the division elected not to file a staff memorandum in this matter. With that, I'll commence my examination of Mr. Turner. Mr. Turner, would you please state your name and business address for the record?
My name is Curtis Turner. My address is 9624 South Vance Court, South Jordan, Utah, 84009.
And what is your current position in relation to Urban?
My relationship is they're a contract broker, and I am president of Turner Petroleum Land Services.
Okay, when were you first contacted by Urban to get involved with this project?
I started running title for Urban back in February of 2020 to run title on the northeast quarter of Section 22 to identify the fee and oil gas owners to obtain leases.
And did what records did you search at that time?
I searched both the Carbon County Recorder's Office and the BLM records.
Okay, I'm going to start a presentation. Can everybody see the screen?
I can.
Okay, good. I'm referring to now what has been marked as Exhibit D, Mr. Turner. Can you kind of explain what this is about and what it reflects?
This is the northeast quarter of Section 22. This is the mineral ownership status of the tracts. There's 16 tracts of ownership, mineral ownership, and this identifies those tracts. Majority of these tracts followed the surface ownership, and the northeast corner or quarter of this is that 40 acres is federal land and is under a federal lease.
The tract that I'm pointing to on the screen right now?
Yeah, that's a currently owned, or that lease is held by Urban Fund 3 and Urban Oil and Gas Partners. The remaining of this 160 acres, the remaining 120 is all fee ownership.
Okay, and go ahead.
Oh, that was it. Just
okay, and after reviewing these records, were you able to obtain leases from some of these owners?
Yeah, when we ran title, we were able to obtain leases for the majority of these people under track 2 through 7, 9 through 14, and 16. That's shown on the RAA.
Okay, and just for the hearing examiner and counsel's reference, These 16 tracks are specifically described on pages 3 and 4 of the request. Can you outline for the hearing examiner what were the terms of these leases that you were able to secure?
The terms for these leases were all a 1/8 royalty with pooling clause, and that is very consistent for a gas play in this area due to the economics.
Okay. Now, turning your attention to the contact that you had with Ms. Nielsen, can you outline for the hearing examiner what was your contact and what were her responses?
Yeah, we sent out lease offer packets to her on August 6th of 2020, and we got no response from that. We followed up on October 6th of 2020, still no response from her.
Okay, and just for the record, what tract does she own the interest in?
She is tract number 15, and she owns a 0.47 acre tract in the northwest of the Northeast, and that comes out to the 0.29375 of the percent of the unit.
Okay, now I'm going to turn your attention to what has been marked, or direct the board to or the hearing examiner, excuse me, to what has been marked as Exhibit F. We do not have a PowerPoint of this because it's several documentation. Referring you to that exhibit, did you prepare that exhibit?
Yes.
Okay, could you please outline for the hearing examiner what it reflects?
This reflects the lease, the lessors in the first column, the effective date of our.
No, if I can interrupt you again, Exhibit F is not on the PowerPoint. If you refer to your exhibit package, it refers to the contacts that you had with Ms. Nielsen.
Oh, I'm sorry, yes. The contacts I had with Ms. Nielsen after were my initial contacts with her, those first two. Then we followed up with our contacts on October 26th of 2020 via FedEx to send her the force pooling packet. And we got no response from that. We followed up on November 6th of 2020 with an additional packet that also had it was to fix an initial problem with the letter. And we got no response from her. But then on I was able to actually meet with her when I was meeting with her parents to get a lease from them. And at that time, she had no interest in leasing. Her biggest concerns were that she needed, she wanted to talk to an attorney, she didn't want to pay one. She didn't feel that we had adequate protections of liability in our lease form. And she just felt that this was not of any interest to her. And so she declined to sign any document. And that was the last communication I had with her.
And let's back up a little bit. In your packages on October 26th, did you include an authority for expenditure in a joint operating agreement?
Yes, I did.
Okay. And when you talk about a clarification letter, was that on December 28th?
That was the December 28th clarification letter to address a misstatement in the letter.
Okay. And then when was the meeting that you had with her and her parents?
I met them for lunch on February 2nd, 2021, this year.
Okay. And just to clarify again, that after all this contact, she indicated she didn't want to participate, and she's had to file, or you've had no further contact with her after the February 2nd meeting?
That is correct. No further contact since then.
Okay. I'd like to point out to the hearing examiner and counsel that Exhibit F does reflect all of the checklist items that need to be included in the notice of opportunity to participate, as in the definition that was promulgated last June. With that, that concludes my examination, Mr. Turner.
Okay, thank you. Division, do you have any questions?
I don't have any questions, but if I may request the hearing examiner to allow Mr. Dustin Doucette to ask any questions if he has any.
Sure, yes. Mr. Doucette?
Yeah, Dustin Doucette for the division. I don't have any questions.
Okay. Fred, we'll proceed with your next witness.
All right, proceed with my examination, Ms. Stifler. Ms. Stifler, would you please state your name and business address for the record?
My name is Catherine Stifler, and Urban Oil and Gas Group address is 1000 East 14th Street, suite number 300, Plano, Texas, 75074.
And what is your current position with Urban?
I am the senior landman that oversees our Utah assets.
All right, would you please briefly outline for the hearing examiner and counsel your education and work experience, and in particular in the drafting and negotiation of joint operating agreements?
Yes. I've been in the industry for about 10 years, and I obtained a master's in energy law from the University of Tulsa in 2015. And since my time as a landman, I have analyzed, negotiated, and drafted model form AAPL JOAs, as well as drafting unit operating agreements. And I'm also a registered professional landman through AAPL.
With that and her resume, Mr. Hearing Examiner, I would ask that you recognize Ms. Stifler as an expert in petroleum land management for purposes of this cause.
Ms. Sosa, do you have any issues with that?
I don't have any objections.
Okay, we'll accept her as an expert.
Thank you. Ms. Stifler, would you please, for the record, state the corporate and bonding status of Urban?
Yes, Urban is a Texas limited liability company with the principal place of business in Plano, Texas, and it is qualified and to conduct business in the state of Utah and has all of the relevant bonding for state and federal.
Since this is Urban's first time appearing before this agency, could you provide a brief background about the company, just so that the hearing examiner and ultimately the board are familiar with your company?
Urban was founded in 2009 by our current CEO, Bonnie Shea, and she was one of the original founders of Merit Energy Company in 1989. And she has over 35 years of experience in direct oil and gas investments. And Urban itself identifies acquisition targets, controls costs, minimizes risks, and does mostly exploit development projects. And we currently have operations in 10 states, including Nebraska and Wyoming, and we have non-op assets in Colorado.
And what was Urban's entry into Utah?
We acquired the legacy Anadarko of the Helper Field and Cardinal Draw Field from Avid Operating LLC in 2019.
And how many wells do you currently operate in Utah?
Roughly 230 across Carbon County and Emery County.
All right, Mr. Turner indicated that the lessees under the federal lease are Urban Fund 3 LP and Urban Oil and Gas Partners C1 LP. What is Urban Oil and Gas Group LLC's relationship with them?
Urban is the duly designated operator of those related entities, and both of those entities have consented to the drilling of this proposed well.
All right. Directing your attention to now what have been marked as exhibits C, D, H, and J as supplemented. Were these prepared by you, Urban personnel, and or myself with your review and input?
Yes, that is correct.
Okay, turning your attention to exhibit C, which is shown on the PowerPoint right now, just please briefly outline what this reflects.
This is just a regional plat map showing the location of the unit in red. And as you can see, part of it does include Price city limits right off of Airport Road, but the well itself will be drilled outside of city limits.
All right, turning your attention now to exhibit D. I know Mr. Turner kind of briefly addressed this, but would you again go over what this represents?
Yes, this is just the tract map that shows that there are 16 different ownership tracts within the 160 acres, and it also shows the proposed location of the well.
And is that well located on a fee tract that you have leased?
Yes, we have all 40 acres leased.
Okay, and what are the drilling plans? When do you plan to drill it, and what are the targeted formation, et cetera?
This will be a coal bed methane gas from the Farron Formation, and pursuant to all regulatory approvals, we plan to drill in August of 2021.
All right, now turning your attention to substitute Exhibit J. Please explain what this shows.
This is just a listing of all the fee leases obtained by Mr. Turner for Urban. And each, as he mentioned, is a 12.5% or 1/8 royalty with a pooling clause. And since they are all the same royalty, the average weighted landowners will be 12.5% for all.
And just to note,
Oh, yes.
I was going to say, just to note that this does not include the Plaza 106 lease because it was just obtained last night.
Correct.
Okay.
And it was also leased on a 12.5% royalty.
Okay, thank you. Now, turning your attention to Exhibit H, there's not a PowerPoint on this. Would you please explain to the hearing examiner what that shows?
This as the pooling declaration. Oh, wait, no,
Yes.
I'm sorry.
That's it.
Is that
Yes.
correct?
Exhibit H.
Oh, Exhibit H. Yes, sorry. Yes, the pooling declaration that was recorded, pooling all of the fee leases except the Gorashek Jesse Etzel estate leases, which were received after the declaration, and the Glenn Nielsen estate, which has currently been mailed, as well as the Plaza 106 lease. But once the leases are received, we will file an amendment to add those to the pooling declaration.
Okay, and what about the requirements with respect to the federal leasing and ensuring that it's properly communitized with those fee leases?
Urban has already submitted a communitization agreement on March 18th that is currently under review and approval.
All right. Is it your understanding that if the board issues a compulsory pooling order, that will facilitate the BLM's approval of that communization agreement?
Yes.
All right. Have you had any personal contact with Ms. Nielsen? Has she ever attempted to try and contact Urban, to your knowledge?
No, I've never had any contact with her.
Okay. Now turning your attention to Exhibit I, the relevant portions of which I will show on the PowerPoint. Was this document prepared by you and perhaps with other assistants within Urban? Is that correct?
Yes, that's correct.
Okay, just explain what this document is.
This is a standard form joint operating agreement. It is very standard in the industry, and it's supplied by the American Association of Professional Landmen. And this is the 6/10/1982 version.
Okay, and is this with the exception of the Exhibit A, which we modified before filing, is this the joint operating agreement that Mr. Turner submitted with his packages?
Yes, that is correct.
All right. Can you address whether the terms and conditions are fairly standard or whether there's any oddball provisions in it?
No, this is very standard. It is along with other forms that we have within the area, and there is no oddball language.
All right. Knowing that there are more current versions of the Form 610, the 1989 and the 2015 forms, is there a particular reason why Urban decided to go with the 1982 form?
Because of the other JOAs we had in the area, it was more for uniformity and consistency.
In your operations, is that correct?
Yes.
All right. On the PowerPoint now, I've highlighted pages 6 and 7 of the joint operating agreement. Can you kind of address what that is, the dealing with the non-consent issues?
Yes, so the original joint operating agreement that we sent out asked for a 500/500 non-consent penalty, but we understood that this, under statutory limitations, is incorrect, and so we are asking for only a 100/300% non-consent penalty.
All right, now turning your attention to the Exhibit C to the joint operating agreement. Can you kind of outline what's in this?
This is just a standard accounting procedure that goes with most joint operating agreements, and it just outlines how we are able to bill our partners.
All right, and what is the interest rate that's allowed under this accounting procedure?
It is the prime rate in effect at Wells Fargo in Denver, plus a 2% max contract rate for fair compensation and to encourage timely payment. Also very standardized.
All right, and then what about the overhead charges?
The overhead we have listed as a fixed rate basis, and for a drilling well rate of $6,500 and a producing well rate of $650, which is standard with the operations that Urban currently operates in the area.
All right, and again, you did not receive any written objection or alternate provisions suggested by Ms. Nielsen to this joint operating agreement, is that correct?
Correct, I did not.
All right, is it your expert opinion then that the terms and conditions of this joint operating agreement with the statutory modifications to the non-consent percentages are fair and reasonable and consistent with those commonly accepted by industry in the area?
Yes, I do.
All right, Mr. Hearing Examiner, that concludes my examination of Ms. Stifler. Oh, excuse me, I take that back. We need to go through notice real quick. I apologize for that. Ms. Stifler, would you refer to the certificate of mailing, which is a pleading that I prepared and is on file with this matter? Do you have that in front of you?
I do, yes.
All right, do you recognize the people that are listed on that certificate?
Yes.
And who are they?
The ones on the front are the parties to be compulsory pooled, although we will be able to remove most of those because we're only doing Sarah Nielsen today. And then all other interested parties that we have received leases from.
All right, and where were those names and addresses compiled from?
They came from Mr. Curtis's mineral ownership reports.
All right, and for the hearing examiner and counsel, the Exhibit Z as supplemented reflects the receipt by the parties or the status of inquiry where we didn't get any receipt back for it. With that, that now concludes my examination, Ms. Stifler.
Ms. Sosa, do you have any questions for this witness?
Thank you, Mr. Rogers. No, I don't have any questions for this witness. Mr. Doucette, do you happen to have any questions for this witness?
No questions.
Okay, thank you. Fred, we'll move on to your next witness.
Yes, this will be our examination, Mr. Wade. Mr. Wade, would you please state your name and business address for the record?
Good afternoon, Michael Wade with Urban Oil and Gas Group LLC, located at 1000 East 14th Street, Plano, Texas, 75074.
And what is your current position with Urban?
I'm the Chief of Operations over our Rockies assets. That is comprised of approximately 445 wells in both Utah and Wyoming, making 31 million cubic feet a day and 325 barrels of oil a day.
Okay, would you please briefly outline your education and work experience, particularly in the Rockies and with coal bed methane wells?
Yes, I graduated in '99 with a degree in petroleum engineering from Texas A&M University. I've worked for majors down to startups and I'm currently with Urban Oil and Gas. My experience spans across 9 states and also the Gulf of Mexico onshore or offshore shelf, with multiple years working operations in Colorado, Utah, and Wyoming. Included in that experience are operations of conventional oil and gas wells, water floods, CO2 floods, coal bed methane, drilling, reservoir engineering, and most forms of artificial lift.
All right, with that in his resume, Mr. Hearing Examiner, I would move that he be recognized as an expert in petroleum engineering for purposes of this cause.
Ms. Sosa, do you have any questions for this witness or issue with him being accepted as an expert?
No, the division has no objections.
Okay, thank you.
Thank you. Mr. Wade, I'm going to now refer you to what has been marked as Exhibit K. It's shown on the PowerPoint. Is this an official business record of Urban?
This is.
And have you had an opportunity to review it after your employment with Urban?
I have absolutely reviewed all of it.
Okay, please outline what it shows for the hearing examiner.
Yes, this is an estimate of our cost to drill a new well over here in our Avid assets. And this lines out both the drilling and completion costs to put this well online.
All right, and this was the AFE that Mr. Turner sent out, to your understanding, is that correct?
That is correct.
All right, and what is the total estimated cost on a 100% participation basis?
It would be $751,750.
And what is the basis for that? I mean, how did you come about doing that with you being new to Utah?
We have not drilled here since we bought this asset. These will be our first wells here. And so we went through the process of reviewing previous drilling in the area and then going and bidding out each of the items here to allow us to TD this well.
And even though these are estimated costs, you're fairly confident that they're legitimate estimates?
Yes, they were put together here within the past year, so they should be pretty spot on.
Okay. Under the statute, one of the elements that can be recovered is a non-consenting owner's 100% estimated plugging and liability, abandonment liability costs. Could you please outline what is the estimated cost that Urban has come up with for this well?
Yes, we estimate that the cost of P&A a well like this would be approximately $65,000.
And what is the basis for that estimate?
We recently P&A'd 2 wells across the border in Wyoming, and while they were much deeper, after backing out the additional plugs and well work, we come down to the $65,000 figure. And that includes the P&A and a reclamation of the land.
All right, turning your attention now to what has been marked as Exhibit L. Was this prepared by you as well?
That is correct.
All right, would you please explain to the hearing examiner what this shows?
Yes, this map here shows in the center our proposed well, and then it shows the distance to the nearest producers. If you look on the map, you'll see numerous dots. The dark dots are producing wells, and then the circles that have little numbers next to them that have ND, those are wells that were proposed, permitted, but never drilled. So as you can see, our well there is quite a ways away from our nearest offset, almost 4,000 feet.
And just for the record, the numbers that are shown on those are references to the API numbers for the wells.
That is correct. Those are the last 5 digits of the API numbers for those wells that were permitted.
Okay, and then under the black dots, the information there is the cumulative production to date. Is that correct?
That is correct. You see there the well names for each of those wells, the cumulative production to date, and then their production from when they started through December of 2020.
Okay, based on the information that's shown here, can you outline to the hearing examiner what are the risks that Urban will be taking by drilling this well?
Yes, there are numerous risks, primarily geologic risks. We are more than 4,000 feet from any nearest producer. And when you look at the offset wells, while most of them are quite prolific, there are still some wells that would be uneconomic if they were drilled today. We also have faulting out here in the helper field, depressed commodity pricing right now. The thickness and the quality of the fair and coal sand varies. Cost of materials, steel has been driving up very recently. Completion risk, these wells need to be fracked, and so there's always a possibility of having a completion issue, screen out those kind of items. And then your typical drilling risks, dry hole, loss of circulation, fishing, those are the type of things that are all risk for us with drilling these new wells.
All right, and so given those risks, Urban's obviously still willing to go ahead and drill this well. Why is that?
That is because we bought these assets and we have additional locations to drill, which will maximize our return for our investors in addition to producing the minerals for the mineral owners.
All right, in your expert opinion then, for the reasons that you outlined and that Ms. Stifler outlined, do you consider a 100%, 300% non-consent penalty as being justified based on the risks?
That is correct.
All right, Mr. Hearing Examiner, that concludes my examination of Mr. Wade.
Okay. Ms. Sosa, do you have any questions for this witness?
I think Fred did a really good job at covering the questions that I had ahead of time. Mr. Doucette, do you have any questions?
No, I think they did a good job covering my questions as well.
I have a couple questions here. On these ND wells not drilled, have the APDs all been rescinded or are they still active?
Most of those are, I believe all of those are expired.
Okay. And who applied for that? Was that your predecessor, Anadarko, or?
That is correct.
Okay. Okay, thank you.
Right, with that, Mr. Hearing Examiner, that concludes our presentation in chief. At this time, I would like to move for admission of the exhibits. In particular, exhibits A through D, F, H, I, substitute J, K, L, and Z is supplemented. If you'll notice, I omitted exhibits E and G. They're moot due to the acquisition of the leases from the parties that were involved with those particular exhibits.
Okay. We will accept those as presented.
Do you mind if I jump in and just double check that Julianne was able to get those? I wrote them down, Julianne, in case you missed them.
Okay. Julianne?
Yes, I did get those. Thank you.
Thanks,
Okay.
Julianne.
All right, with that,
Thank
Mr.
you.
Hearing Examiner, if I could just reserve some time after the division statement for closing.
Sure. That'll be fine. Okay. Haley, would you like to present the divisions, please?
The division doesn't have any specific presentation to give. As a general matter, the division supports the request for agency action and would suggest to the hearing examiner that it be approved.
Okay. Let me just, can we go offline a moment and I can discuss with my counsel briefly? Charles, how do you want to do this? You just want to give me a call?
Sure, I can just give you a call.
Charles, can you hear me?
Yes,
I'm having, do you have the number you need to call me on?
I just called it and it directed me to a different number, so I'm calling that one.
Oh, that was probably my office number.
656-7741.
Yeah, that'll work. Sorry about that.
Okay.
Okay, we're back. Charles has a question he'd like to raise, if we could bring that at this time. Charles?
Yeah, just real briefly, Fred, during your presentation earlier, you moved for that order of default, or made that motion for default against Ms. Nielsen. And I guess just in any written proposed order, if asking if you're gonna write a proposed order of default separately from any kind of proposed order. I'm just curious how that would be addressed.
In previous hearings that we've had, usually it's just addressed in the order that the board signs that they granted that.
Okay, that's fine. That's the only question I wanted to ask about that. Thanks.
Okay, and I just want to make sure we got that out there. So after hearing all the evidence and presentation, I move that we suggest before the board that we accept this order as written or as presented. All the issues as far as risk and have been addressed, and notification. You've had direct contact with Ms. Nelson. I think that it shows a significant work on your part. So Fred, would you go ahead and prepare that order?
I will. And I'd like to thank everybody for their time, and especially the technical staff. Went very smoothly today again.
Yeah, I was the only one that glitched out, so I apologize for that. So anyway, thank you to all. And at that time, we'll conclude this hearing unless anyone has anything else.
Well, thank you.
Okay, thank you.